Hi, I'm Nate Charles, and welcome back to the Rule of Law Brief. Today is the third in a series of 3 videos inspired by one of our viewers. That viewer posed some questions about the situation going on with the Caribbean boat strikes. He asked whether the war crimes involved could also possibly be crimes against humanity. He asked whether U.S. personnel could possibly face some sort of prosecution in any sort of international tribunal. And finally, he asked about the International Criminal Court. Now, after reframing his questions just a little bit, I answered the first 2 in a previous set of videos. Today, I want to talk about the somewhat unique relationship that the United States has with the International Criminal Court. Specifically, I want to talk about why the United States, as one of the loudest voices in the room on human rights and the laws of war, refuses to join the International Criminal Court, and why, in recent years, that refusal has evolved from cautious distance to open hostility. From the very beginning, the United States viewed the International Criminal Court from 2 different angles. On one hand, the International Criminal Court was the embodiment of the international rule order that the United States had superintended for almost 80 years. But on the other hand, the ICC is also a potential threat to sovereign control over American military and intelligence operations. And candidly, why wouldn't the United States view it somewhat skeptically? At the moment the Rome Statute was finalized, the United States was the most powerful country in the world. Submitting to an external criminal tribunal could not possibly strengthen U.S. power. It could only constrain it. Joining the International Criminal Court offered the United States at least one strategic upside: promoting international rule of law. But there were also plenty of downsides, because the only meaningful effect would have been to place limits on the very hegemony that defined America's post-Cold War dominance. The United States was deeply involved in negotiating the Rome Statute, and President Bill Clinton actually signed it on December 31st, 2000. But the U.S. Senate declined to ratify it, meaning that it never gained domestic legal effect. Then, in May of 2002, George W. Bush took the extraordinary step of formally unsigning it. He informed the UN that the United States rejected any obligations arising from its prior signature and would not join the International Criminal Court. But keep in mind what was going on in May of 2002. The war on terror had just kicked off. We were in the first 6 months of operations in Afghanistan, and as history has shown, we were, in some instances, doing some pretty shady stuff. That move effectively nullified the statute both as a treaty and as an executive agreement for the United States. If you want to learn more about the difference between a treaty and an executive agreement, go to charlesinternationallaw.com/research library. We have articles on those topics. The underlying logic of George W. Bush pulling out of the ICC has remained constant for decades. No external court may sit in judgment over American personnel. But here's the inconvenient truth. The International Criminal Court almost certainly does have jurisdiction to investigate U.S. nationals when alleged war crimes occur in the territory of ICC member states. Afghanistan, Poland, Lithuania, Romania each falls squarely within that rule. Despite that, the United States has made it unequivocally clear that it will never permit the ICC to prosecute U.S. nationals. And that, valid jurisdiction on one side and absolute political refusal to join in the prosecutions on the other, is the paradox that drives this whole topic. The United States' relationship with the International Criminal Court is where the admittedly idealistic rule of law narrative of the United States runs headlong into realpolitik. Once you appreciate that jurisdictional paradox, the broader U.S. position comes into focus. The United States supports international criminal justice when it aligns with U.S. strategic interests: extraditing warlords, documenting atrocities by adversaries, legitimizing accountability mechanisms abroad. But that support vanishes the moment the ICC scrutiny approaches American conduct: CIA black sites, drone strikes, special operations, or the actions of close allies. Cooperation tends to turn into resistance. The U.S. wants the ICC active everywhere except where it could apply to the United States. That inconsistency is baked into the design. So again, the International Criminal Court operates on the principle of complementarity. It only steps in where the nation states who participate in the Rome Statute fail to take care of matters within their own house. But the ICC has repeatedly questioned whether U.S. internal investigations have been independent, complete, or aimed at senior decision makers. Its investigations have found that war crime victims frequently were never interviewed, that authorized interrogation practices that met the definition of torture were never genuinely examined, and that high-level accountability for those actions never really materialized. From the ICC's viewpoint, this looks like unwillingness. From the U.S. viewpoint, the ICC butting in looks like foreign interference. There's not a whole lot of middle ground. Now, when the ICC moved forward with investigations involving U.S. personnel or close allies, Washington responded not with diplomatic distance, but with escalating resistance. Allies found themselves caught: support international justice or placate the United States. Financial institutions and NGOs began preemptively aligning with U.S. pressure to avoid consequences. The United States, once the architect of this rules-based system, now appeared to be bending those rules to shield itself and its closest allies. Global perception started to shift. The United States was no longer avoiding ICC jurisdiction, it was actively working to undermine it. For almost 20 years, previous presidential administrations upheld a delicate balance. They avoided joining the ICC, but still affirmed its legitimacy. They promoted international rule of law, but they supported the ICC's cases selectively and avoided direct confrontation. They stayed out of it, but they didn't try to destroy it. The Trump administration blew that shit up. The recurring theme around here. Trump's America First nationalism made the ICC an easy target, but what followed went far beyond rhetoric. It reflected a deeper retreat from the rule of law, consistent with Trump's authoritarian impulses and his tendency to bully institutions that he can't fully control. Senior ICC prosecutors and judges were financially sanctioned. The United States actually froze their finances. Their ability to function was disrupted. Organizations assisting war crimes investigations found potential criminal liability. ICC staff became unsure whether ordinary legal work put them at personal risk. Some investigators just outright resigned. This wasn't just a disagreement. It was retaliation. It was a superpower trying to intimidate an international criminal court out of doing its job. It marked a decisive end to the bipartisan diplomatic courtesy that had once defined the U.S. relationship with the ICC. So let's be honest. The United States relationship with the International Criminal Court is justice for thee, but not for me. The double standard is glaring. The U.S. helped build the international justice system. It invokes it when others commit atrocities, but it refuses to let the same rules apply to itself. Now, to be fair to the United States, in the past, the U.S. had more robust internal oversight mechanisms than many of the other signatory states to the Rome Statute. We had inspectors general, military justice systems, internal watchdogs. Those systems uncovered real misconduct. And besides that, none of the previous internal watchdogs within the United States changed the global perception that the U.S. demands accountability from others while shielding itself. That perception undermines American credibility and corrodes the moral foundation of American leadership. And this is where the entire issue becomes even more consequential. As the United States drifts towards authoritarian patterns, its claim that it can police itself becomes far less credible. Think about the opening days of the second Trump administration. One of the first things that he did was fire all of the inspectors general that we had just mentioned previously. Authoritarian movements always produce a two-tiered system of justice: impunity for allies, targeted prosecution for their enemies. They erode oversight, corrupt institutions, politicize law enforcement, and weaken judicial independence. Once internal accountability weakens, the ICC's principle of complementarity begins pointing in the opposite direction. The court acts when national systems are unwilling or unable. That threshold becomes easier to satisfy when a country's institutions are under political pressure or being hollowed out. In short, the more the U.S. retreats from the rule of law internally, the more justified ICC intervention becomes externally. For decades, the United States defended its ICC exemption by arguing that it had strong internal mechanisms for accountability. But that argument only works if America remains a rule of law democracy. If that changes, the world will notice. And so will the ICC. One of the fundamental principles of leadership is if it's good enough for your men, it's good enough for you. U.S. policy toward the ICC has never met that standard. And as the U.S. drifts towards personalized authoritarian rule, the contradiction becomes impossible to hide and increasingly indefensible.